From the Library of Congress in Washington, D.C.
Yes, good afternoon. Welcome to the Library of Congress. I'm so delighted to see so many of you here today and join in with us at the Law Library of Congress as we celebrate Constitution Day. First off, I want to thank the Friends of the Law Library of Congress. They are a separate entity and they are a very big supporter of the Law Library of Congress, and without their generous support, this program would not be possible today, so thank you to the Friends. So we're here to celebrate Constitution Day. Congress established Constitution Day in 2004 as a federal holiday to recognize the ratification of the U.S. Constitution in 1787. The legislation in 2004 was introduced by the late West Virginia Senator Robert Byrd, and it expanded on the celebration of Citizenship Day, which was previously created during the Truman administration, to recognize those who had become U.S. citizens during the previous year. But in combining these two observances, the benefit is that we can now celebrate all who become citizens under the Constitution and the Constitution itself. Now, the law in 2004 mandated that all publicly funded educational institutions provide programming on the history of the American Constitution as a way to commemorate this great event in our nation's history. The Law Library of Congress, as a unique legal institution that not only serves as Congress's primary source of U.S., foreign, comparative, and international legal research, but also provides resources and services to the national and global legal community. So we are therefore very, very honored to be able to celebrate the Constitution in this way. And this year, we're particularly excited because we have Dahlia Lithwick, who is joining us again. Some of you may remember that she joined us last year, and she had such a terrific program that we invited her to come back this year, and we are very delighted that she flew all the way from Israel to come and do this. She's spending a book year, or book leave, I guess it's called, from Slate magazine to spend time in Israel to write a work on her forthcoming book, which we hope to celebrate next year. Pressure's on. And so we're very, very delighted that she's able to be here with us. Last year, you'll remember she talked about interesting things such as television cameras in the courtroom and public access to the court. Today, she plans to tell us about some of the U.S. Supreme Court's noteworthy decisions from this most previous term. She will talk to us about some of those cases that have occurred this past year. She will talk to us about what she expects to see this coming year. So this promises to be a very exciting program. So let me tell you a little bit about Dahlia, but I'm sure she needs no introduction. She is the senior editor and legal correspondent at Slate. She writes the Supreme Court dispatches and jurisprudence columns for that magazine. Her work has also appeared in many other publications, including The New Republic, The New York Times, and The Washington Post, and she's frequently a commentator on National Public Radio's news magazine, Day to Day. Back in 2001, Dahlia received the Online News Association Awards for online commentary for a series she co-authored on torture, and she was the first online journalist to serve on the steering committee for the Reporters Committee for Freedom of the Press. As I'd mentioned earlier, she is spending this year in Israel working on a book, and I believe that book is going to be about women Supreme Court justices, I'll let you tell them what it's all about and make sure I get that right. And we look forward to hearing more about the Supreme Court and everything else that she's doing. So if you join me in welcoming Dahlia Lithwick. Thank you.
Well, thank you so much to David, to Robert, to Clifford, to all the good folks here who brought me back after last year. I should, just by way of disclosure, tell you that all of those of us who lived through the past year with the healthcare hearings at the Supreme Court are suffering from some mild form of PTSD. I mean, we've all lost basic social skills, and we, if you make us sit down for 5 straight hours and talk about the Commerce Clause, we weep. So we're all broken as a class, the Supreme Court press corps. But I'm going to try to rally and talk to you today. I've been tasked with the job of telling you a little bit about last term, what the upcoming term, the court itself, and maybe some lofty thoughts about the Constitution and the importance of Constitution Day to boot. And I want to just start my remarks by saying that it's really worth thinking about the fact that if we had been talking here 3, 4, 5 years ago, we might not have such an animated discussion about the Constitution. The one really remarkable thing that we have seen emerge in the last 4, 5, 6 years is an absolutely reinvigorated national conversation about what the Constitution means, what states' rights are, the balance between the federal and state authority to make determinations about our lives, fundamental questions that really map beautifully onto my topic today, which is, how is it that the Constitution is relevant, and how is the court thinking about those things? And so I really want to say that even though, regardless of which team you were hoping for in the healthcare cases, even though it may look as though the other side, whoever they may be, have kind of weaponized the Constitution of late, the truth is the fact that we're all fighting and grappling and struggling with constitutional questions, and we're not just doing it in the court, we're doing it on the airwaves and on the blogs, and when the guy is parking our car at the restaurant. So I think it's really worth stopping and realizing that no matter how frustrating and maddening the national conversation about the Constitution is, we are having it. And that in and of itself, I think, is important. So I want to just start by telling you a little bit about the Supreme Court's cases from last year. And they include, a conversation about fleeting expletives. Fleeting expletives is a nice way of saying that if on a television award show, Nicole Richie, say, blurts out a swear word and it doesn't get beeped out in time, does the network have to pay? Fleeting expletives has, for reasons that are not entirely clear to me as a doctrinal matter, has also come to sweep in brief flashes of human buttocks that somehow make it onto television shows as well. So the court had to look at the policies surrounding those. The court very famously addressed itself to GPS devices this past term, trying to determine if a GPS device put on a suspected drug dealer's car that stays there long after the warrant had expired, and he obviously didn't know, if that violates his Fourth Amendment right to privacy. The Constitution still matters so much in cases like that, in cases involving Arizona's attempts to frame its own immigration laws, in a sense that the federal government wasn't doing the job correctly, and so Arizona was going to kind of tilt the balance between federal and state powers, and the court addresses this question. And again, famously, the federal government's effort to create a national solution to the healthcare problem. Again, this touches on and inflects into so many important constitutional questions. So the Constitution is alive and well, and even when you thought you weren't debating about the Constitution, if you were debating those issues, you in fact were. So at the center of all this, of course, is the U.S. Supreme Court, which is, as we all know, completely unaccountable, completely unbothered by polls, by protests, by numbers that they see in the New York Times, unaffected by the lines of people standing outside the courts with signs and hats and horns and bullhorns. The Supreme Court that is institutionally created to not care what we think. The Supreme Court that is utterly inscrutable and unknowable to us. We get opinions at the end of the term, but we won't know for decades not until the justices' papers are released, what really happened. We won't know how those conversations went in conference when the justices had to make decisions. And so what we know really is the end product, but not the process, not the arguments, not anything about the real meat of what happened in negotiating those opinions. And the Supreme Court, which is really, in a profound way and a mysterious way, completely unknown and unknowable to us. And I don't just mean unknowable in the sense that Sandra Day O'Connor says when she says more people can name the judges on Dancing with the Stars than can name one justice on the Supreme Court. I mean, the fact that we know nothing about the court is certainly problematic, but I just mean we don't know who these people are. We don't know them as individuals. They're very unreadable. We see them in black robes, deliberately mystified in a white temple. We can't get in with our cameras. We can't get in with our tape recorders. You can stand in line for 4 days before the healthcare cases, as people did, and not get into the building. And so the Supreme Court really is in an age and era with no mystery. When people are blogging their pedicures, the Supreme Court is the last mystery left in America. And I think a lot of us have problems with that. And what I want to tell you is that I think it's easy, too easy, to tell a familiar story based on what I've just said about the Supreme Court. They're inscrutable, they're unknown, and unknowable. And the story we like to tell, and I know we like to tell it because we in the press deliver it twice a day to our editors, is that the court is an assemblage of 9 political actors divided right and left. They are essentially what their votes were in Bush versus Gore. They are essentially what their votes were in Citizens United, the campaign finance case. That it is a court that is polarized between 4 liberal justices and 4 conservative justices, and in which Anthony Kennedy reigns as king, the swing voter at the middle that nobody knows what he's going to do, and we love to tell that story. You may remember the cover of Time magazine the week before the healthcare decisions came out was about Anthony Kennedy and inside the mind of Anthony Kennedy, because we all thought he was going to be the determinative vote in that case. And I think we tend to think that about every case. I like to joke that Supreme Court reporters walk around with little bracelets that say WWKD, what would Kennedy do? Because that is all we talk and think about. And that's an easy story to tell about the court. And the last easy narrative to tell about the court is that they're simply elite, and they're out of touch, and they're old, and they don't know who we are, and they don't care. And those are the stories we tell, and those are the stories that get printed and published. And I want to stipulate for a minute that all that is true. That in fact, this is a sharply polarized Supreme Court. And in fact, with the loss of David Souter and John Paul Stevens, we now have a court that for the first time in decades has every member voting the way the president who appointed them would have had them vote. In other words, we have 5 conservatives who were appointed by Republicans and 4 liberals who were appointed by Democrats. And that is a tragedy. It's a really sad thing to happen to the court because it means it's so easy to tell that story about a 5-4 court that is liberal and conservative. It is also dramatically polarized right now. And I would be lying if I said the healthcare hearings and the healthcare opinion weren't extremely underpinned with ideology and politics and not just law. And I think it's also fair to say that the court is quite aloof and quite out of touch. I think now more than ever, it is fair to say that the justices come from 2 law schools. Their clerks come from about 8 law schools. Many of them really are proud of the fact that they don't read newspapers. So the justices are as cloistered as they have been, and not just cloistered, but I think also really in a slightly adversarial position with the country in a way we haven't seen before, and I want to talk about that in a minute. But what I want to tell you is that even though everything I just said is true, and that every easy narrative about the court is true, it's also not true. It's not the whole story about the court, And in part because it's Constitution Day, and in part in the spirit of Wallace Stevens' poem, 13 Ways of Looking at a Blackbird, I want to offer you 5 other ways of looking at the U.S. Supreme Court, 5 other narratives that I would ask you to try out as you think about the court this coming term. So first and foremost, I want to suggest to you that one story you can tell yourself about the court is that it's a court, that it is in fact different from the political branches, that it is in fact unelected, that the justices serve for life, that they don't answer to us because by design they are not supposed to answer to us, and that they are insulated because by design they are meant to be insulated. And that doesn't make them a political branch that is not functioning properly. That makes them a court. And we forget that sometimes when we tell the story of the court. And so those that like to tell the story about, oh, this is a purely Citizens United, Bush v. Gore, 5-4 Punch and Judy show, when they tell that story, what they have to do is ignore the fact that for many, many years now, most of the court's cases are decided 9-0 or 8-1 or 7-2. So you cannot, in fact, say, oh, this is a 5-4 court, everything is decided along political lines, because most of the cases are not. Last term, in fact, 44% of the cases the court handed down were decided unanimously. That's an enormous number for a court that we want to call a partisan political institution. Now you're going to say, Dahlia, wait. Only the small cases are decided unanimously or 8-1. But in fact, that's not true either, because of course the healthcare cases were decided either 7-2 or 5-4, depending on what part you were looking at. The Arizona immigration case, the Papers, Please case, was decided 6-3. The GPS case I told you about was decided 9-0. The case involving whether churches could have a ministerial exemption, a religious exemption to the civil rights laws, also decided 9-0. And the Texas redistricting case about the Texas redistricting maps and the constitutionality of those maps also decided 9-0. So these aren't the sort of boring little fishing cases. These are major, major cases that move the needle in important areas of law, and all of them are decided by margins that don't fit the 5-4 story we like to tell ourselves. And the other thing I would say on this 5-4, it's just a Bush v. Gore court story, is that this court has actually been quite minimalist. They have tried very hard to follow the Alexander Bickel rule, to do as little as possible. And so in many of the cases I've just described to you, including the fleeting expletives case, the FCC indecency case, including the GPS case, including the Texas redistricting case, they have done as little as they possibly could to resolve the issue. And so it's very, very easy to say, oh, this is a court that just wants to belly up to the bar and be in the middle of every national controversy, and then decides everything on the same margin every time, but it's simply not true. And what I want to suggest to you is that it's a court, first and foremost, because of Chief Justice John Roberts' vote in the healthcare decision. Because whatever you think of the merits of that decision, it is clear to me that the Chief Justice decided to put the institution first and to put the integrity of the institution first, to take it out of the story about the election, which is the way we would have talked about the healthcare case, and to really undermine the idea that the court just simply is a vending machine that pops out 5-4 decisions day after day the way they would pop out a Snickers bar. And even the leak that happened at the court, and I'm sure you all know the story, that immediately after the healthcare decisions came down, there was a truly unprecedented leak where rumors about how the negotiations played out were released to the press, and we were told that the Chief Justice changed his vote at the very last minute. I want to suggest to you that even the leak, as it played out the way it would at a court, and that the Chief Justice's decision not to respond, the other justice's decision not to respond, is the difference between a court and a political body. So that as that issue faded away and everybody stopped thinking about the leak, what we were able to say was, the way this played out is because, first and foremost, it's a court. Now, I want to suggest to you that the second thing that the court is, the second story you can tell about the court when your friends try to sell you the 5-4 narrative, is to say it's not the Kennedy court. It is not the Anthony Kennedy court. It is true that he is a critical swing justice. It is absolutely true, as Time magazine suggested when they put him on the cover, that we all thought he was going to be the pivot, the fulcrum around the healthcare cases. But it is also true that Anthony Kennedy, while he votes right with the court on some issues, with the right wing of the court on, say, abortion, affirmative action, healthcare, and votes left with the court on some issues, including gay rights, juvenile sentencing, and the war on terror. Even though he does that, he's not any longer completely the fulcrum of the court. So for last term, Justice Kennedy was in the majority 93% of the time. So yes, his vote matters enormously. But this term was really interesting because this term, Chief Justice Roberts was in the majority 92% of the time, or within the margin of error. So it is quickly becoming not just the Kennedy court, but also, I think, the Roberts court. And Chief Justice Roberts, not just in the healthcare case, but in many, many other cases, has tried to reappropriate that center spot on the court for himself. So I think it's going to be very, very hard in this coming term to say, WWKD, what would Kennedy do? I think that there are profound changes at the very sort of fulcrum of the court, and we're going to see how those play out. One other thing I want to say before I leave Justice Kennedy is that the person who voted most often with Justice Kennedy this year, and these statistics are all thanks to SCOTUS blog, which if you don't read religiously, you should, but the person who voted most often with Justice Kennedy this term was Justice Kagan, which suggests to me, again, that there is some interesting movement at the court, and that breakdown of that easy 5-4 definition is really starting to take place with Justices Kagan and Justice Roberts playing key roles. So now I want to tell you, because I have just flagged it, why I think Justice Kagan and the Chief Justice are starting to shift the center of gravity at the court. And if I'm right, and if that compromise that we saw in the healthcare case, where Chief Justice Roberts comes together with Justice Kagan to fashion a majority in the Medicaid, the second part of the case, the Medicaid expansion, then that's worth looking at and saying, what is happening between those two? And so I want to tell you my third way that I might frame the Supreme Court as not just the 5-4 story. And I think in that sense, it's an intergenerational court. And that what we're starting to see at the court is one generation, an older generation, that probably does fit that 5-4 narrative pretty well, but then a really intriguing set of changes in the younger generation, in this generation of 50 and 60-year-old justices who are going to try to think past that easy framework. So I'm just going to give you 4 numbers: 79, 76, 75, 74. Those are the ages of 4 of the oldest justices on the court. If you do the math, that means that by the 2016 election, those numbers will be 83, 80, 79, 78. This court is going to change radically between this election and next. I don't think just one justice is going to step down. I think it could be as many as 2 or 3. But what's really intriguing to me is that if we think about the justices who actually managed to craft a compromise in the healthcare case, I think it's not an accident that it's 2 of the justices who are thinking about a long game. It's justices who are going to be on the court for 20, 30, maybe 40 more years. And what I think they did, and I have no inside background, but what I think they did was say, if we dig in now, if we make this Bush v. Gore, if we make this Citizens United, we are in for 30 more years of this. And I think they tried to find a middle space where they could work together. I think some of what we're seeing in some of the angry dissents that came out of the courts this year, again, not an accident, coming out of that older generation of justices who are in their late 70s and may feel as though they haven't managed to shape the constitutional world in a way that they wanted to. And so I think the real frustration at the court comes out of justices like Justice Scalia and Justice Breyer, and even in the ACA case, Justice Kennedy, who feel that they haven't quite managed to accomplish what their life's work was supposed to be, and who are these upstarts coming up behind them who are changing everything around. I think this problem is going to be exacerbated because the presidents are going to always have an incentive to pick younger and younger nominees. And so I think we're going to continue to have a big generation gap between the older justices and the younger justices. And I'm hoping that the end of this particular story, what I'm calling my story number 3, is that younger justices realizing this is a very long game and the stakes are very high, and there's not just one case or 1 year or 2 years or 5 years at stake, are going to figure out ways to reach across the aisle and make the court less polarized than it is today. So this brings me to my 4th story that I want to tell about the court. And that is, I think this is a court that is under extreme pressure. It's under extreme pressure both from within and extreme pressure from without. From within, I've already hinted at truly the sea change that happened when those leaks came out of the court this term. None of us who cover the court had ever seen a contemporaneous leak to a journalist where what happened at conference was divulged in such detail. And truly, not since the book The Brethren has anyone at the court told a reporter a story like that. And I think that that will fundamentally affect the court this coming term. I think that the fact that someone spoke to a reporter about what are supposed to be absolutely top secret deliberations will have to affect the dynamic as among the 9 justices. I also think that the fact that whoever it was that leaked quite literally launched an attack on the Chief Justice and questioned his integrity will also, I think, shape the way the court thinks about itself and the way the justices think about each other this year. It was truly, I can't say this strongly enough, a violation of all the norms that the court holds dear. And before the healthcare case, you may remember there were an awful lot of sort of stories in the press about how is it that the court doesn't leak? How can we not know? The president must know. Romney must know. Someone must know. Someone's secretary's wife had to get drunk, and someone knows, some clerk knows, and yet we didn't know. We didn't know because we never know, because the court just doesn't leak. But now it leaks, and it may continue leaking, and that is going to change everything. I also want to suggest that the court is really under attack in its mind from without. And this goes a little bit to what I said in my remarks last year, where I talked about how the court feels quite assailed by the media and quite violated and assaulted by the attention on their personal conduct. I think the justices feel now more than ever that they are receiving very unfair scrutiny, and whether it's reporters with iPhones who take their picture when they're out at fundraisers for certain causes, or whether it's calls for their recusal, I think the justices themselves feel that some kind of trust has been broken with the nation, and they're quite worried about the esteem of the court if you're going to start calling out individual justices for bad behavior. Now, I want to say that and say it in the same sentence that I say the following. Sometimes the bad behavior exacerbates the problem. And whether it's Justice Scalia right now in some kind of strange literary smackdown with Judge Richard Posner from the appeals court, or whether it's justices attending fundraisers for partisan groups, or justices failing to recuse when there's a sense that they are compromised in a case, I think that there is certainly grounds for the American public to closely scrutinize the behavior of the court. But I think it is certainly the case that the justices feel that they are misunderstood, that they are being threatened, and that the American public doesn't understand that what they do is not political. And I also want to add to that this one gloss, which is going into this current election, we heard an enormous amount of bombastic attacks on the courts from candidates who wanted to do all sorts of things to cut back the power of the courts. And so it's not entirely imagined on the part of the justices. Institutionally, I think there is a sense in this country that the court has way too much power, and whether it's congressional attempts to roll cameras in there, or whether it's Newt Gingrich saying he's going to have marshals drag judges before Congress to defend their decisions, no matter who it is or how it's coming out, I think it is undisputed that the rhetoric around the courts is very, very heated right now. And I think that makes the justices very nervous. So I think that both in terms of their own relationships, but also in terms of the court as an institution and its relationship to the American public, I think there is a deep sense that something is going wrong and that the court isn't safe as an institution. It is absolutely not an accident that although the 9 justices agree on absolutely nothing as a matter of doctrine, the one thing that they will all speak about and speak about and speak about is the integrity of the judiciary and the need for an independent judiciary and their sense that that has been violated. The last frame I want to offer you to think about, both last term and the upcoming term, is the following. This is not the Rehnquist court. And so I have talked about Bush v. Gore and Citizens United as though those are interchangeable, but of course they're not, because between Bush v. Gore and Citizens United, we had 2 key retirements at the court and 2 key replacements. And with Chief Justice Rehnquist and Sandra Day O'Connor departing the court, with Chief Justice Roberts and Samuel Alito arriving at the court, it's all too easy to say it's a wash. It's the same court, just, Sandra Day O'Connor looks better in a dress than Sam Alito does. But that's not quite right. And here's the frame in which I want to think about the court right now going into this current term. It's not the Rehnquist court because the Rehnquist court was fiercely protective of states' rights, because both Rehnquist and O'Connor felt very, very strongly about that issue. And if you think about the so-called federalism revolution, which saw its high watermark in the Lopez case or the Morrison case, the cases on Rehnquist's watch, where quite explicitly the court talked about the dignity of states, I think that era is well and truly over. And if you look at the 2 big decisions that came down at the very end of this term, one of them was the Arizona immigration law, where the court determined that no, Arizona doesn't get to set its own immigration policy, which is truly, truly, I think, a rebuff to the idea of states' rights. And more pointedly, the healthcare case, which was at bottom an effort by the states to say we want to regulate this on our own terms. And again, the court says there's a value that's more important, and we're going to allow this to be decided at the federal level. I think it's fair to say that both Chief Justice Rehnquist, who cared deeply about states' rights, and Sandra Day O'Connor, who came from a state legislature, who really was defined by the fact that she came out of Arizona and out of that legislature and has a deep, deep deference for the legislative decision-making of the states, would have had a much harder time with these cases. And if I'm right that this is not a states' rights court, I think I might also be right that the health care controversy, for all the screaming and the shouting and the drama, wasn't really the issue for the Roberts Court. If the Roberts Court doesn't deeply, deeply care about the authority of states, and remember again, both Roberts and Sam Alito came through the executive branch. They didn't come up through their states. They really came to government, I think, as believers in federal power. So if I'm right that the Roberts Court was never going to be all that sympathetic to claims of states' dignity and states' authority, it raises the question, what are the issues that the Roberts Court really will splinter along? And I think if you look at the writings of both Chief Justice Roberts and Sam Alito before they came to the court, it may be that the era of states' rights and the Federalist Revolution was over before it began for them. And the issues that keep them awake at night are abortion and affirmative action and gay rights and the separation of church and state, which are all the issues that are coming up to the court this term. And if I'm right that those are the issues that really, really will fracture the court along ideological lines, then this will be actually the term of the century, as opposed to last term, which was an interesting Commerce Clause question and certainly did fracture the court on an ideological basis. But I think this term is going to be the term to watch. I think this term is going to be the term to watch because it raises a lot of issues that are very dear to these justices and to all the justices. So I want to just take a minute and briefly highlight the cases that are coming up down the pike. And probably the most important one, and the one you've heard of, is the affirmative action challenge that's going to come up from University of Texas. And the Texas program basically has a 10% rule, where the top 10% of all high school students immediately get into UT. This challenge is going to be brought by Abigail Fisher, a student who wasn't in that 10%, who felt that she would have been entitled to a slot after that 10%, but for considerations of race. Race is still used after the 10%, and so she's challenging the affirmative action policy at Texas. I think it's fair to say that, and remember in 2003, the court looked at this issue in Grutter in the Michigan affirmative action cases, and they kind of set the clock. And in an opinion, Justice O'Connor said, we're not quite ready yet to do away with affirmative action, and we're going to hang on to affirmative action for the purposes of fostering diversity in schools. I think the clock may ring this term, and I think the court may well strike down the Texas affirmative action policy. It's certainly a case to watch for. I think it's going to tell us an enormous amount about where the court is on issues of race. And I think it's important to also flag that Chief Justice Roberts, in the Seattle schools case, in the case that had to do with the voluntary desegregation of Seattle and Kentucky schools, was quite explicit and quite clear when he said his own view is the way to stop thinking about race and dividing us by race is to stop dividing us by race. In other words, the Chief Justice doesn't like race-conscious policies, and I think there may well be 5 votes who feel as strongly as he does about it. Another case that's coming back to the court is about the Alien Tort Statute. This is a case that was actually argued last year, and the court has ordered re-argued. This involves a statute that is a very, very arcane and old statute that has been used by human rights groups to bring challenges to human rights violations in other countries by other parties. And the Supreme Court showed itself last year when it was argued to be very, very dubious of the proposition that people who suffered in Nigeria, who suffered human rights violation at the hands of corporations, could be sued here in the United States. So I think it's probably fair to say that in asking that the case be re-argued, the court is opening the door for doing away with the Alien Tort Statute, at least as it applies to corporations. There are 2 dog sniff cases. If you're a dog lover, it's always fun to go to the dog sniff cases because you find out how the justices feel about dogs, something that is always deeply intriguing to me. There's never cat cases at the U.S. Supreme Court. There are 2 dog sniff cases coming up this term. Incredibly interesting privacy questions and Fourth Amendment questions about whether a dog sniff is more like a police search or more like something neutral that doesn't invade your privacy. The court has been pretty clear in recent terms that dog sniffs are permissible when we're talking about, say, luggage at an airport. That doesn't violate your privacy. But these involve the home. A dog sniff in Florida where the outside of a home was sniffed by a dog, and that was seen as grounds for probable cause to get a warrant. Another was a private truck. So these 2 cases are going to come, and the court's going to have to do a little bit of hard work to determine whether a dog sniff violates your Fourth Amendment right. The other cases that we don't know about, although we may know about tomorrow, and in that one sense, I wish I were talking to you tomorrow, are the gay marriage cases that the court is actually talking about in conference today. Now, they may not grant today. They may kick them off a little bit, but if my spidey senses are still working after a few weeks in Israel, I would tell you that I think we're going to get a grant on a gay marriage case this term. The court has a couple to choose from. They have the Defense of Marriage Act is being challenged. That is the 1996 statute that bars you from having, even if you're married legally in a state like Massachusetts or New York, but you cannot get federal benefits for that marriage. That's been challenged in many courts around the country, and the First and the Ninth Circuit have struck down DOMA on the Defense of Marriage Act. So those cases are before the court. The other case that's before the court is Proposition 8. That's the case that comes out of California, where by referendum they try to do away with the right to gay marriage, and a district court judge there issues a very, very sweeping defense of the right to gay marriage, which is narrowed somewhat by the appeals court. So that now at this point, Proposition 8, that case stands for the idea that only in California and only if the citizens take away a right that was already given to you by the state, then it is you can't take away the right to gay marriage. So it's an incredibly narrow decision, which makes it less likely that the Supreme Court wants to hear it. What they probably have to hear is the DOMA cases, because you have federal courts striking down an act of Congress. I think there's a sense that it's a much bigger deal. So if you're calling your bookie, say, while I'm talking, you might want to tell them to put money on the DOMA cases with the because I know everybody bets on the Supreme Court. With the promise to look at Prop 8 at the California case down the road. And the final case that I think is in the hopper that is very, very likely that the court will hear is the Voting Rights Act cases, which are really enormously consequential to the way we vote in this country. Section 5 of the Voting Rights Act provides that certain states with a history of discrimination on the basis of race have to get pre-clearance from either the Justice Department or a panel of judges in the District of Columbia before they can change their voting laws. And essentially, this is a challenge that is brought by various states who say they just don't want to be cleared anymore. It's too onerous. The history of racism in voting is over, and they want to be treated just like the good states. So we've got challenges likely from Alabama, from North Carolina. I think there's a very, very good chance that the court takes these cases, and I think, again, based on a Texas case that we saw a few years ago, where the court more or less sent out a warning shot and said, boy, we really, really hate these preclearance obligations, that there's a good chance that the court does away with Section 5. Now, I am not Wallace Stevens. I'm not even Dr. Seuss. I don't write poems. And the court is not a blackbird, so I'm not going to go on with 13 ways to look at the court. But I will say, if you wanted to look at the court as not a 5-4 enterprise, another frame to think about is that for the first time we have a court comprised of 6 men and 3 women, and that changes everything. For the first time we have a court comprised of 6 Catholics and 3 Jews, and that changes everything. And for the first time, we have a court that has almost everybody coming out either off the bench or academia, without civil rights lawyers, except for Justice Ginsburg, without criminal defense lawyers, without trial court judges. We have a very narrow bandwidth of experience at the court. And all of these ways are frames through which to look at the court going forward. So I want to urge you, not when you're fed the easy, oh, it's always 5-4, it's always Kennedy in the middle, and he's just flipping a coin. I want you to push back a little bit and say that the court is as complicated an institution as any other institution in government, and it's worthy, I think, of closer scrutiny. So I want to close, because I want to take your questions, but I want to close by just saying I've talked a lot about the stories that we tell ourselves about our Supreme Court, or the singular story that we tell and how I think it's wrong. But I want to suggest to you that there's a really other important story, which is the story that the court tells itself about us and who we are. And as I said to you, the court is very insulated right now, more insulated, I think, than it should be. And so I'm going to suggest to you that you may not think that our voices matter to the court, but they do. And what we think and how we feel matters to the court. And obviously, with an election coming up and all those 70, 70, 70, and 79-year-olds, our vote also will matter at the court. So we are as important in this story about the court, whether it's what we're writing, what we're thinking, what we're arguing, as they are to us. I think it is a mutual relationship, and it's easy to forget that when they're obscured by black robes. And so I want to close by just saying that Justice Scalia likes to remind people that most national constitutions don't last a generation. Ours has lasted over 200 years. And the reason it's lasted is because we're in it. We're in that game, and we're fighting over it, and we're bickering over it. And the guy who's trying to fill my teeth is asking me about the Commerce Clause. We are very much where we should be in our conversation about the Constitution, which is having it, as opposed to just letting the justices have it. And so I urge you, not just today on Constitution Day, but really every day that you're thinking about the court, to think of the court as something that is alive, as something that is vibrant, that is complex and nuanced, and as an institution that is as dependent on you as you are upon it for its legitimacy and our own, and to really take the time to think very, very hard and very deeply about what the court means and what the Constitution means. And that's why in 200 years, I think we'll still be having a Constitution Day. Thank you very much. I'm happy to take questions about anything that I've said or anything I haven't said. Yes?
Why do you think the Roberts Court will keep leaking?
I don't know that it will keep leaking, but I think that the fact that there was a leak will make that taboo slightly less of a taboo. And I think that if you are a clerk, and remember the law clerks are told, I mean, after the Brethren, they were told, never talk to a reporter. If a reporter calls, hang up the phone. And they really didn't. They didn't. Nobody leaked. And I think that there is a sense in which once it's happened, all bets are off. I think that the clerks from last term, the justices, their wives, the clerks for this term, now have a sense that maybe nothing happens when you leak. And that's what worries me. And I think they have a story to tell too. And I think that there's a sense that if an injustice was done with that leak and a misperception was floated out there, it needs to be corrected. And so my sense is not only have we kind of crossed a boundary that we've never crossed, but that there's going to be ill feelings and there's going to be a desire to, I don't want to say pay back, but I think to correct the record. And one of the real problems with the court, is that we're not going to find anything out for decades. I mean, it's the nature of the court. And there may be people at the court for whom decades is too long. Yeah?
I wonder if you could say a little bit more about the DOMA cases. If they do take one, which one will it be? What will the result be? Will it decide it on rational basis or heightened scrutiny?
I don't know. I know that, there's a huge and quite exciting fight going on between the groups because the DOMA cases were quite deliberately set up to be the test cases. The plan was always to go slowly and incrementally. The DOMA cases are much more attractive vehicle, I think, for the pro-marriage groups because they raise questions of federalism. They raise questions of can the states just not do it themselves. Those are incremental, narrow questions. The Prop 8 case kind of came out of nowhere. And there was a real feeling that here's David Boies and here's Ted Olson, and they sort of helicopter in to save the day by bringing a challenge in California and, raising huge, epic, equal protection claims and huge and epic privacy claims that are way too early and that the courts are not ready to hear. And so I think there was a sense that they were kind of upstarts that came in from nowhere. And really, I think there's a definite sense that there's a foot race between these two to get to the court. I don't know if it's going to be the New York version or the Massachusetts version. I think it could be several. I think that, as to the question of what the court will do, say it with me now, what would Kennedy do? I mean, I think this is the case where Kennedy really will be the decisive vote. I think he's the only person whose vote is in play. I think that if this is an attractive vehicle for him to really go the next step, and remember, Kennedy was the justice who authored Lawrence versus Texas. That was the gay sodomy statute that he invalidated in very, very sort of sweeping language about privacy and family and the right to raise your family as you saw fit. It's language that really, I think, maps onto the facts of the DOMA cases quite deliberately, as I said. So really then the question becomes whether Kennedy is ready to do this at some level. And I think there is some sense, and the other thing I should say is that the great fear underpinning all this is that if the court isn't ready to do it, we will have moved hugely backward. So this will really become Bowers versus Hardwick again, and we will have all the progress that's been made on this issue will be reversed, and we will have set the cause back for several generations. So there's an enormous amount of strategic worry that this is too much, that the court doesn't want to get ahead of the zeitgeist, and that the zeitgeist isn't quite there. Recall that even though courts are striking down DOMA, every place that this has gone to the ballot, it has been defeated. So there's a real question about whether this country is ready for this issue. And I think it's interesting that the justice who has talked most pointedly about the court not getting ahead of the sort of cultural norms and where people are is Justice Ginsburg, who has said, maybe Roe was just too much too soon and there should have been another way to do it. So I think the justices are trying very hard to triangulate against this question of, is now the time, is this the moment, and how can we do this? So I think the way to do it is to sort of bring this states' rights question to the center and to say this, in the end of the day, is a deeply conservative proposition, because not only are we for marriage, which is a deeply conservative notion, but we are for letting the states determine whether they can do that which the states have always done. And so my sense is that's probably, if there's something that the court could get comfortable with, I think that's the way to get comfortable. And I think when I ask myself, as I do 3 times a day, what would Kennedy do? I think my answer on this is, it seems to me that Kennedy's trajectory on this issue has been quite pronounced. Kennedy has gone from having real problems with gay rights to being the most robust defender of them. And so I think somebody in his mid-70s who perhaps sees his tenure at the court beginning to end might well think this would be a sort of noble way to end his career, to have this be sort of the capstone of that line of cases that he's written. But I don't know for sure, and I think I would add one other thought, which is the Kennedy who dissented in the healthcare cases was as conservative as any Kennedy I've ever known. And so this is one of those ways in which it will be interesting to see if what happened in the healthcare cases does something to push him farther from the center. I don't know for sure, but I think my bottom line is I think this really is going to come down to, if he wants to be that guy, if he wants this to be his legacy, and as I said, if this is the right moment, and I think he would worry a lot about whether this is the right moment. So that's my long, short answer. Yeah.
I have a question about your role.
Mm-hmm.
Why do you, maybe it's two questions, so many questions. Why do you think they added extraterritoriality, and do you think that the fact that they did that means Kennedy or somebody is trying to roll back Ortega?
I don't know. I have to say, and I haven't watched it because I sort of took off after last term, and so I really can't do justice to the question. I would say, having sat through the argument, that there were more than 5 justices who were deeply, deeply skeptical about the whole project. It was surprising to me, the antipathy toward using the ATS for anything, and that I did not have a sense that there were justices on the fence in the first go-round. I had the sense that they would have happily done something very, very, it felt like Citizens United to me, that it was being re-argued because there was a sense that this is just awful. And I think it was, for me, the biggest surprise of the term in terms of tone. And so Justice Alito, Justice Scalia, Justice Roberts had no patience for any part of using the ATS for anything, and I thought it was not a close question for them. So I don't know the sort of doctrinal answer, but I know that I was shocked at the level of impatience they had for the whole exercise. Yep.
Are there any big cases affecting local authority this year?
Local authority, not that I know of offhand, but I should tell you, this has been a stunningly, usually the docket is much fuller now than it is this year. They have granted cert on stunning low number of cases. And so which is the other reason that whenever people say this is going to be a snoozer of a term, they really have a lot of cases to grant still. So again, I'm a little bit apologizing about the fact that I'm not starting in a week, so I'm not as up on how this term is going to go. Anyone else? All right, well, I want to thank you very much. I think there's food in the back, and I wish you a very happy Constitution Day and 200 more.
This has been a presentation of the Library of Congress. Visit us at loc.gov.